Schools of There have been several schools of thought that came into existence in respect to the philosophy and meaning of law. These schools of thought came into existence as a result of the fact that there is no general accepted definition of law. In other words, there have been a lot of controversies and disagreement over the philosophy and meaning of law, and schools of thought emanated as a result of these controversies. These are the major schools of thought. First, naturalist school of thought. Second, positivist or imperative school of thought. Third, realist school of thought. Fourth, Marxist school of thought. Naturalist school of thought. Naturalist school of thought is the first school that came into existence in respect to the philosophy and meaning of law. Naturalist school draws its inspiration from nature. They believe that there is a law of nature which tenets and principles human beings, most especially how man ought to behave. They based their arguments on the ground that since human nature is identical in all men and do not vary in spite of culture, historical and geographical environments, that law is from nature. Naturalist school is the oldest school of thought in the study of law. They believe that law is made by God and not by man. They are of the opinion that law should not be man-made. The argument is that if law is made by man, it would lead to tyranny and despotism. They believe that law is made by nature. Invariably, law is made by God and man is ordained to obey the law. Law is from God to man, not from man to man. Thus, according to this school, law should state what man ought to do, not what man must do. This implies that law should be normative in character, not imperative. They state that law should have content of morality, that any law which does not have content of morality should not be regarded as law. Basically, the dominant task of naturalist school of law is to attune man-made law to the demand of universal conception of moral standard. They see law as the same thing with moral rules. The naturalist school of thought also claims that fundamental human rights provisions, which can be seen in almost all modern constitutions, were derived from natural law. Fundamental human rights are natural and inalienable rights endowed on human beings by God, not by human enactment. Imperative positivist school of thought. Imperative school of thought did not believe on ethics and morality. They state that law should have nothing to do with morality, because morality and law are not the same. Positivist school is of the opinion that law is made by the state. Invariably, this implies that law is made by man because state is just an abstract entity. It is the human beings that are used as machinery to pilot the affairs of the state, which means that law is made by man and for man. They argue that law should be imperative in character, not normative, which implies that law should state what man must do, not what man ought to do. It was on this ground that the chief proponent of the school, John Austin, defined law as a command of sovereign backed up with sanction. According to Austin, there are three cardinal elements that must be observed before a rule can be regarded as law, such as element of command, element of sovereign, and element of sanction. What it implies is that law must be like a command. Command is an order from the superior to an inferior, in which if the inferior fails to obey the order will attract some punishment. So law should be like a command. The command must come from a sovereign entity. That implies, for the command to qualify to be law, it must be from a state or constituted authority, and there must be a sanction or punishment if someone violates the law. Realist school of thought. This school states that law is made by judges, not by legislative arm of government or legislators. Realist does not give any importance to laws made by the legislative arm. They assert that enactment of law should be arrogated to the judiciary arm of government. They uphold judge-made laws as the genuine laws. This school states that any law made by the legislative arm is not law because such law is still subject to judiciary interpretation, and it is the interpretation given by the judge that becomes law. The realist school denounces traditional legal rules and concepts, concentrates more on what the court actually do in reaching the final decision in the case. It is based on this ground that Oliver Wendell Holmes sees law as prophecies of what the court can do in fact, and nothing more pretentious. This school believes that law is what the court has decided in respect of a particular set facts through its judicial pronouncement. Marxist economic theory of law. This theory was propounded by Karl Marx. According to Karl Marx, in any given capitalist society, there is existence of two classes, upper class and lower class, class of superordinate and class of subordinate, class of superior and class of inferior, class of rich and class of poor. According to Marx, every person in the society belongs to either the class of rich or poor. The socio-economic status of a person is used to determine the class which he belongs. If the socio-economic status of the person is high, that means he belongs to the class of rich. But if the socio-economic status of the person is low, he belongs to the class of poor. In the capitalist society, the class of rich subjects the class of poor to perpetual exploitation. Thus, according to Karl Marx, the rich people in the society instituted law as an instrument of oppression used for the purpose of facilitating the exploitation of the poor people. Karl Marx strongly asserts that law is simply the manifestation of the interest of the dominant class in the state. The capitalists normally use law to maximize their profit at the expense of the poor people. The people from high socioeconomic status in the society usually institute law in order to protect themselves and their properties, while the life and properties of the inferiors or lower class are not safeguarded. He believes that was never made to serve the interest of poor, rather it was made purposely to protect the interest of the rich. That is why he sees law as an instrument of oppression, intimidation, and exploitation in the hands of the rich against the poor.